Welcome to the deep dive. Today we're asking a pretty terrifying question, actually. What happens when you just fire the judge, fire the lawyers, and let a few lines of Python code decide if you broke the law?
Yeah, I mean, it feels like the premise for a, dystopian sci-fi thriller or something, but it's a very real, incredibly urgent debate happening at the highest levels of government right now.
It really is. And that's exactly our mission today for you listening. We're going to unpack this proposition making massive waves in the tech and legal worlds, which is converting the law directly into automated software code.
Right. Literally a lot of code.
Exactly. And we have a fascinating stack of reading to help us navigate this. On one side, we've got an article published in the Economic Times by Himanshi Lokab and Shubham Chakraborty, and they report that the Indian government, specifically MeitY, which is the Ministry of Electronics and Information Technology, is actively exploring this law to code solution.
Right. And the goal there is to enforce the Digital Personal Data Protection Act, the DPDP Act.
Yeah. And then balancing that out, we have a really sharp, relentless rebuttal from a critic named Naavi. And Naavi just breaks down exactly why attempting to execute this automated vision could result in, well, a total regulatory catastrophe.
A complete disaster, yeah.
Okay, let's unpack this, because the core tension here is wild. You have the seductive idea of fighting modern AI cyber threats with automated governance, like fighting fire with fire, right? But the nightmare scenario is removing human beings from the legal equation entirely. I mean, imagine a world where a software algorithm, just, code running silently on a server somewhere, automatically issues massive financial penalties to a corporation in the blink of an eye.
Yeah, no human weighing the context at all, just instant machine execution.
Exactly.
And what's fascinating here is that the initial rationale presented in that Economic Times article, it actually makes intuitive sense when you look at the reality of modern cybersecurity. The authors quote this anonymous cybersecurity expert who points out that AI-powered cyber attacks, they operate at machine speed.
Wait, let's break that down for a second. Because the notes mention the Anthropic Mythos threat model as an example. I know Anthropic builds AI, but what is the Mythos model specifically doing in this context?
Right, so the Mythos framework essentially illustrates how an advanced AI could autonomously exploit systems.
Yeah.
So it's not, a human hacker sitting in a hoodie typing out individual passwords.
Right.
It's a machine generating thousands of unique, highly sophisticated attacks per minute. It scales infinitely. It's adapting to firewalls and processing vulnerabilities at a speed the human brains we can't even comprehend it.
Oh, wow. So the logic here is if the attack is happening in milliseconds, the defense cannot wait for a lawyer to, draft a cease and desist letter.
That's the exact argument.
Yeah.
The article suggests that governance and compliance must also operate at machine speed. If an AI system attempts to access personal data without valid consent, the law-to-code software will supposedly catch it and automatically block it. They argue the entire implementation of the DPDP Act can just be handed over to an AI without human intervention.
Meaning you effectively eliminate the need for vast legal teams.
Exactly.
I mean, that sounds almost too convenient, right? Like a perfect automated shield. Does our critic, Naavi, buy into this premise at all?
Not at all, no. Naavi suspects this entire narrative might just be a calculated PR exercise by a software company.
Oh, interesting.
Yeah, looking for a lucrative government endorsement from the ministry. The critique even floats this bizarre possibility that the quote-unquote official quoted in the article might actually be a synthetically generated AI persona.
Wait, really?
Yeah.
A fake AI persona advocating for AI governance?
Yeah, used to manufacture momentum for a specific product.
That is definitely a modern twist. But, okay, let's set aside the potential PR spin for a minute and look at the actual mechanics. How do you actually translate a legal statute into code? Because to me, it feels like asking a computer to perfectly enforce the rule, be a good friend. How do you write deterministic code for something that requires so much human context?
That is a brilliant way to frame the underlying vulnerability. And it brings us to the first major structural weakness Naavi points out, which is that legal language is deliberately vague. It's structurally ambiguous by design.
See, I'm not a lawyer, so when I hear deliberately vague, I usually think of bad writing or like a sneaky loophole. Why would you write a law that isn't crystal clear?
To accommodate reality, I mean, a legislature simply cannot foresee the infinite variety of human circumstances. So the DPDP Act uses terms like reasonable security safeguards or permissible purposes.
Or significant data fiduciary, right?
Exactly.
But a computer needs a 1 or a 0. It doesn't do reasonable. If I'm a programmer tasked with building this system, how do I write a script for that? Let's say I'm writing a function, something like def check retention, to enforce a rule like do not retain data beyond a permissible duration.
Right. And that is the exact brick wall the developers are going to hit. Imagine that programmer sitting down to write the script. The software has to ask, what exactly is the permissible duration?
Yeah, what's the number?
Exactly. To answer that, the code needs to know the taxonomy of the data. Is it medical data? Is it marketing analytics? Who verified the original purpose?
And what if, the retention limit has technically passed, but the data is being lawfully held because the company is suddenly involved in an unexpected lawsuit?
Yeah, the machine lacks the human capacity to weigh competing exceptions like that. It would likely just flag the data as illegal or worse, automatically delete it.
Destroying evidence in the process. Wow!
Right. To put this in perspective, look at the European Union's GDPR, which has been enforced since 2018. Highly paid lawyers and judges still regularly debate what the term legitimate interest actually means in practice for different businesses.
Yeah, so if decades of jurisprudence haven't settled the mathematical definition of legitimate, a Python script certainly isn't going to.
Furthermore, we have to consider how law and software age differently. Law evolves, right? Courts issue new judgments, they reason by analogy, they adapt to new social norms. But software ossifies.
It just sits there.
Exactly.
Yeah.
A rule encoded in software in 2024 is going to blindly enforce the 2024 interpretation of that law indefinitely, unless a developer explicitly patches the code. You're replacing a living, breathing legal system with a brittle, slow-to-update legacy software system.
Okay, here's where it gets really interesting. If the machine makes a mistake at scale because it's enforcing an outdated or flawed interpretation, the obvious question is what happens next?
You've just hit on what the source calls the meta-accountability gap. Under our current frameworks, a compliance failure is usually a human decision. It could be traced, it could be audited and contested in a court.
Right.
But under law to code, a compliance failure is an algorithm producing the wrong output across millions of transactions simultaneously.
Let's put some concrete numbers to that scale, because the notes mention India's DPDPA Act carries penalties of up to 250 crore rupees per violation. For anyone listening outside of India, that is roughly 30 million US dollars per violation.
It's just a staggering financial risk.
Yeah. So imagine an enterprise's automated system incorrectly classifies a massive batch of routine data. In a fraction of a second, it triggers 10 million simultaneous violations. We're talking about economy crashing numbers. Who takes the blame for that? The enterprise running the system, the government ministry that mandated the base code, the software vendor who wrote the buggy script.
There is no clean answer in any jurisdiction right now.
Yeah.
By trying to get rid of the human lawyers, we're actually removing the primary error correction mechanism in the legal system.
Which is the adversarial human layer.
Exactly. Lawyers exist to catch each other's errors and present nuanced context to a judge. When you automate that away, fast enforcement of a wrong rule scales harm instantly.
Yeah, if you run a small business, or let's say you're a medical researcher operating right at the edge of what is considered a permissible purpose for tracking a rare disease, you might need to hold data longer than standard rules allow because a new symptom appeared.
Right.
A human regulator would look at that and say, yes, legitimate interest, keep the data. But the algorithm might just say, 30 days expired, delete the data, or face a $30 million fine. You can't exactly reason with a firewall.
You really can't. It creates a massive chilling effect on innovation and legitimate work. And this raises an incredibly ironic vulnerability regarding the very threats this system is supposed to stop.
Wait, yeah, because the whole justification for this law-to-code push was to stop advanced AI threats like the Anthropic Mythos model.
Right, but Naavi points out a critical flaw in that logic. Law to code doesn't eliminate the attack surface. It just relocates it.
I'm not sure I follow. It relocates it from where to where.
Think of it this way. Human laws are like a maze with flexible walls. A human judge can move a wall if you have a good excuse or uncover a nuance. But software code is a maze made of solid concrete.
Okay.
An advanced AI attacker doesn't need to argue with a human judge or beat human lawyers in a courtroom. It just fires millions of data packets at the concrete walls until it finds a microscopic crack.
Oh, like a tiny logical loophole in the code.
Exactly. And then it floods right through it.
Oh, I see. We've taken the ambiguity of the law, which is actually a defense mechanism because it requires human reasoning to navigate, and we've replaced it with a brittle software vulnerability.
Yes. The adversary just probes the code for false positives or exploitable exceptions. And this isn't hypothetical. The source reminds us that tax compliance software is constantly exploited. Financial risk models are gamed all the time.
Right. Fraud detection systems get adversarially probed every single day.
Exactly. There is absolutely no reason to expect a data protection enforcement algorithm to be immune, especially when it's operating at a national scale.
Okay, so if the machine is making mistakes and attackers are finding loopholes, the next logical question is, who actually designed the concrete maze? Let's talk about the political economy of this code.
Yeah, this is perhaps the most profound weakness identified in the text. As the critic notes, who writes the base code writes the law.
Hold on, I want to make sure I understand the implications of this. If a government ministry writes the underlying code for this compliance system, how does that shift the balance of power?
Remember those ambiguous terms like permissible? The legislature wrote them vaguely on purpose. The courts are constitutionally empowered to interpret what they mean. But if a ministry engineer writes the code, they are the ones deciding what permissible actually translates to in the software.
Bypassing the legislature and the courts entirely?
Entirely.
That is wild.
Yeah.
The engineers at the ministry become the supreme arbiters of the law, but it's completely hidden behind the text.
Yeah, it becomes this massive concentration of state power, but it's cleverly dressed up in the neutral language of algorithmic objectivity.
That feels incredibly insidious. Because as a society, we tend to argue less when a computer tells us no. Think about social media feeds, right? We don't know why a post is downranked. We just accept the algorithm did it.
Right, we just shrug.
Yeah. If a human regulator hands down a fine, we push back. We file an appeal. But if the software says the algorithm flagged this transaction, it shuts down the conversation. People assume the math is unbiased.
It makes the interpretation of the law less visible, less contestable, and immune to oversight. And this gets infinitely more complicated when you realize that data does not care about national borders.
I was just thinking about that. How in the world does a rigid algorithm handle the messy reality of the modern global internet?
It really can't. Let's look at a cross-border scenario the source provides. Imagine an access request originates from a US-based engineer. That engineer makes an API call to maintain a global system, but the server processing the data sits in Singapore. The user whose data is being touched lives in India, and their consent was originally obtained under a privacy policy drafted to comply with European GDPR rules.
My head is spinning just listening to that setup.
Right. And the kicker is, what if the company's legal obligations under U.S. national security laws directly conflict with their privacy obligations under India's DPDPA Act?
A human legal team would have to sit down, look at international treaties, weigh the business risks, and figure out a nuanced path forward. How does the law-to-code algorithm handle it?
It fails. The algorithmic solution just blindly defaults to one single jurisdiction's interpretation and pretends the others don't exist. You cannot encode all of those conflicting global obligations simultaneously without producing a mathematical contradiction that just, crashes the logic.
And Naavi points out a really cynical byproduct of this whole government-sponsored mechanism. It actually gives data fiduciaries, the companies legally responsible for protecting your data, a massive excuse.
Yeah, if a company is essentially strong-armed into using this government-approved software agent and a massive data breach occurs, the company can just throw their hands up.
Right.
They can defend themselves in court by saying, we used the state-mandated software, we followed the approved base code, therefore, this breach is a non-punishable implementation issue.
The government essentially assumes the liability for the tech companies. That seems like a legal nightmare for the state. Is anyone challenging this legally?
The text highlights a crucial Supreme Court angle. The DPDPA Act is already facing challenges from public interest litigation or PIL lawyers in India's Supreme Court who are arguing the law itself is unconstitutional.
So Naavi is arguing that this move by the ministry is like handing free ammunition to those lawyers.
Yes, the text explicitly warns the government's legal defenders that actions like this actively weaken the state's stand. Naavi references a famous local political meme in India, the idea of a machine where you put aloo, or raw potato, in one side and get solid gold out the other.
Oh, I love that. It's a metaphor for absurd, magical thinking. You feed messy, complex human context into a black box server and expect perfect, flawless justice to pop out the other side.
Exactly. It's a fantasy that conflates speed with accuracy. Fast enforcement of a correct rule is great, but fast enforcement of a wrong rule is mathematically catastrophic at scale.
So what does this all mean? We've looked at the ambition, which we agree is understandable. Governance does need to keep pace with AI threats, or we'll just be overwhelmed.
Mhm.
But the execution proposed here, this literal translation of law to code, is deeply structurally flawed. Is there a way to salvage this?
Well, our source doesn't just tear the idea down. It offers a much more pragmatic architecture.
Hmm.
We need to separate automated compliance tooling from automated legal interpretation.
Walk me through that difference.
Tools that help operationalize compliance,
Yeah.
like a scanner that warns you if data is stored unencrypted. Those are genuinely useful.
Yeah.
But software that determines guilt and issues a penalty without human review, that is constitutionally fraud. The ideal system relies on machine speed monitoring, but retains human-in-the-loop decision authority.
So you use the AI as an incredibly fast bloodhound. It flags the probable violations at lightning speed, but a human judge or regulator actually reviews the context and issues the penalty.
That's the only way you keep the adversarial error correction process alive. You let the machine do the heavy lifting of sorting the data, but you leave the actual judging to humanity.
And this is so incredibly relevant to you listening right now, because as AI continues to permeate your workplace, your industry, and your daily life, you are going to encounter these automated compliance systems more and more.
Absolutely.
If you run a team, or if you're just clicking agree on terms of service, understanding the critical difference between a tool that alerts you to a problem and a system that judges you without any human context is going to be essential for navigating the future of work.
Because if we surrender that human context to the sake of efficiency, we give up the core of what makes the legal system function. Which leaves us with a final thought from our research today, something to really chew on as you go about your week.
Let's hear it.
If we eventually succeed in building a machine that can perfectly execute the law exactly as its creator biased it to do, how long will it take before we start demanding the fundamental human right to be judged by a flawed, slow, but empathetic human being?